Hello, everyone, and thank you for joining our webinar. My name is Mirel. I'm attorney at Sorainen, and I am responsible for moderating our first block, which covers, amongst others, different aspects of fundraising in the US. After the first block, I will give the floor to Kaido Kynnapas, who will lead discussions on different option schemes. As an introduction, I think it's also important to clarify why we decided to organize such a webinar. Namely, we have seen in our practice that at some point of time, a lot of Baltic startups have some interaction with the US market. Will it be due to fundraising, expansion of business, exit, or something else? And if it happens, we have seen that the startups face a lot of unexpected issues and difficulties they need to overcome. So the purpose of this webinar would be to provide you an initial understanding of the main things to consider and expect when deciding to enter the US market. To provide you this overview, we have invited to our first block Taavi Annus from the US law firm Brian K. Layton Basner, who has assisted a lot of startups to overcome the issues they face when starting in one way or another to conduct the business in the US. In addition, we have invited Ulla Helm, head of legal from Veriff, and Vitenis Pušas, CEO and co-founder of nanoAvionics, to join the panel to give you the insights on the issues they have faced and also how they have managed to solve them. So how our panel will be structured. First, each of our panelists will make a general introduction and provide a general overview of their insights to the matter. And then we will have a joint panel where everyone can share their experience. During the presentation, we will also try to cover the questions you have provided prior to this webinar. You will also have a chance to ask questions during the panel in writing in the Q&A section. And we will try to respond to these either orally or in writing, but as trying to be mindful of the timeline, we may not be able to respond all of the questions, in which case we will provide the responses in writing after the webinar. So that's it from my side now, and as promised, I will give floor to Taavi Annus.
So I'm really pleased to be here and present to you about taking a company to the US.
A couple of times after I started speaking.
There are actually many ways to go to the US. I mean,
maybe let's go.
Can sell goods, services from abroad, direct to customers. We can use local distributors.
So,
we can use US joint venture partners. We can set up a US subsidiary, or what the focus today will be is we can establish a US parent with a foreign subsidiary, presumably in one of the Baltic countries when you come from the Baltic countries. My focus, as I said, is establishing a US parent mostly for fundraising purposes. But a lot what I'm going to talk about also applies in other contexts. I'm going to give you a general overview of what it does mean to do business in the US and what legal things you have to be aware of. So why would you want to go to the US? I found an interesting statistic in first quarter of 2021. A record $69 billion in US venture investments were made, which is 41% more than the previous record. Right now, the fundraising is even easier because of the post-COVID situation or COVID situation in many places. Face-to-face meetings are not as expected as they were. Raising funds in the US seems to have never been easier. Exits are very common. The big SPAC mania, special purpose acquisition companies, have given tremendous new exit opportunities to the startups. Why not to do it from abroad? Many US investors do not invest in companies abroad. There are some accelerators that require the company before joining them to incorporate in the US. There is a tremendous startup network, a lot of know-how, the startup infrastructure with various service providers. And some of the things from legal perspective are actually easier. There is limited or no notary use, which I've always had fun to when dealing with Estonia, at least, of having to run everything by the notary. Signatures can be done easily. There's very limited public information about you. You can be in the background and publish what you want. The documentation tends to be pretty standard. So for as you start. Now, not everything is good though. Why you shouldn't come to the US? Just because you have a Delaware corporation does not mean that investors will actually invest in your corporation. If you have no really connection to US, no customers, no employees, your technology is not applicable to the US, you will just be unattractive to US investors. And there are plenty of investors outside the US. Many US investors also invest abroad, and startup infrastructure is no worse in other countries. Some of my first venture investment deals that I worked on were actually US investors investing abroad. And I think I've worked with about 4 or 5 investors who have done investments in foreign countries. And that can be at any stage. I have an early stage venture fund that seeks out foreign companies for various reasons. I'll get to this more. Operating a company in the US can be costly, especially if you are from abroad. You can go to US without establishing a US parent. I mean, we know all, even from the Baltic states, very good examples. I don't think, I mean, Skype, I don't think ever established a parent in the US, or thinking about TransferWise or Wise. And there are many, many examples of companies successfully staying in Europe, but establishing US operations as well. And the decision to reverse later and go back to the Baltics can be even harder later for various tax and operational reasons. So what I'm gonna give you is what we in the US would call business law 101, or issues that every startup or every company, frankly, that goes to the US will have to face when they set up operations in the US. It's not, US is not a Wild West where there are no legal rules. All the legal issues that I'm going to point out are in the end manageable, but they do require time and resources to deal with. Why is it important? The investors, when you raise money in the US, they expect the companies, both mature companies and startups, to comply with the various legal rules. It's part of investor due diligence. In the financing documentation, you would have to give representations and warranties. And investors too actually pay attention. You may be required to take steps after the investment to fix things, but very often the investors will insist that things be fixed before they actually fund. And it can be harder to fix problems than to get them right from the beginning. I mean, that is kind of investor demand, why you have to be aware of this. There's a more kind of more immediate reason. You don't want to go to jail, as many startup founders have tasked me, keep me out of jail. So, intro to law when you come to the US. I can tell you that the first steps of setting up a US company is incredibly easy. Vast majority of startups are formed in Delaware. There are good reasons for that. Delaware is, I don't actually remember when I established a company outside Delaware. It is a very good legal system. People know what to expect there. We can set up an entity there within hours. We can also, and your US lawyers will tell you that they will have a startup package of corporate documentation of bylaws and board and stockholder consents and your equity incentive plans and the founder agreements and the confidentiality and IP assignment agreements, maybe basic shareholders agreement, all that's needed to set up a company. You will then have a company, and getting there is easy. where things become more interesting is in the next steps. What do you start doing with a company? And that is more difficult, particularly for foreigners. I mean, the first difficulties I always encounter is the company wants to open a bank account. The bank account opening rules and regulations have become so burdensome that it usually takes a fair amount of time to just get a bank account set up. You need a tax ID from the IRS to open a bank account, and you usually have to show up. And a little anecdote, to get a tax ID for a foreigner who doesn't have a foreign owner who doesn't have its own tax ID or social security number in the US, you still have to fax an application to the IRS. And then the IRS will take a couple of or several weeks to process a fax and send back you by mail or fax the response with your tax ID, which for anybody from the Baltics seems probably just crazy, but that's how it still operates. Now, those are kind of more technical points, bank account or tax ID. The operations in the US also need to comply with a variety of federal, state, and local rules. US is not a US, it's not Delaware. It's a collection of 50 states and a bunch of local jurisdictions. If you are in San Francisco or you are in New York City, there are some local rules on top of the New York State rules and California rules. And that becomes even more complicated if you're in regulated industries such as fintech or insurance or healthcare that are largely state regulated. And you have to comply with rules in every state that you operate, which is not easy. Going through some main areas where I've seen businesses coming to US have struggles and where they need help. The first one is taxes. I'm not a tax lawyer. In the US, it's actually common to engage a tax accountant to take care of your taxes. And this is highly recommended as well. Who will help not only with filing your tax returns, but also tax structuring, tax planning, and general advice. They do this all the time, and they are just more efficient to do it. But why do you need one? Delaware is no tax haven. You have to file tax declarations, pay taxes on taxable income if you have any. If you set up a Delaware corporation, you would probably file a federal tax return as a matter of course. If you sell products in the US broadly, you may actually have sales tax related obligations throughout the US, which in the past couple of years has become more strict in many states. And my clients who, let's say, sell retail products within the US have had to spend tremendous amount of effort to set up their sales tax related obligations in every single state that they sell to. Second topic that I see pretty much every startup struggle with in the US when they raise funds is securities laws. Offering and selling securities, whether it be shares or notes or safes to investors, requires an exemption from registration requirements, meaning that unless you want to do an IPO, which you cannot do when you are just a startup, you have to find a rule that allows you to sell those securities without doing an IPO. Typically, US startups raise funds from accredited investors, which means certain individuals and entities that meet wealth criteria. You also need an exemption from for granting stock options and other equity incentives to employees. All of this is manageable, but there are very specific steps that the company needs to take to be able to raise funds. A big difference between Baltics and US is everything related to employment and benefits. The US employment system at first seems like a Wild West. It's at-will employment as a rule, meaning that everybody can be fired at any time for any reason. Except there are some anti-discrimination rules that prohibit you from firing people for certain enumerated reasons. So it is expected that if you don't belong to any of those protected categories, employment agreements usually allow employees to be let go. But if you do belong to certain enumerated categories, whether you are older or you're female or you are disabled, then the risk from the company's perspective of engaging in discriminatory action is something that we frequently have to advise companies about. For that reason, by the way, it's incredibly common to also have employment practices insurance in the US. So if you were to get sued by a former employee, you have insurance that covers your legal costs for that. Once you hire employees, you have additional tax registration, filing, withholding obligations. You have to get what is called a workers' comp. Not too unusual and not too different from the Baltics. But what is again different is each state has its own employment laws. And for example, California and a couple of other states, you cannot have any form of post-employment non-competition agreements with your employees, which comes as a surprise to many who come to the US. Another difference from the Baltics for sure is that US does not really have government-provided employee benefit plans. So it is really the duty of the company to ensure that their employees have health care or start contributing to a retirement plan. And the question is, when do you want to do it? There are service providers that help companies to navigate this world, but it's something new to deal with. Startups often face what I call a deferred compensation traps. US rules are very strict about how employees can defer what the compensation they receive. And even if the employee totally agrees to defer the compensation until a certain event in the future, the US rules are very strict that you cannot do it unless you meet very strict criteria. Not too unusual from the Baltics, but a focus of investors is an employee contractor classification issue. A reaction of many companies is, why don't we even hire employees? Let's just use service contracts and hire people as independent contractors. Something that is somewhat similar to a concept in Estonia that I learned, the O-Ütamine, where people use all their companies to provide services, but the tax authorities think they should really classify as employees. Same issues come up in the US, and the risks there and investor diligence are not insignificant at all. Other topics to deal with and to think about when coming to the US. US litigation risk is definitely higher than in Europe. If you engage in some business and sell broadly to customers, you are at risk of being sued in class actions. The general rule is that in lawsuits, each party bears their own legal costs and pays their own lawyers. The prevailing party doesn't necessarily prevail or get the legal costs reimbursed. So at a minimum, the companies coming to US need to quickly start thinking about basic insurance package. General liability insurance, D&O insurance, which protects directors and officers against suits against them. E&O, or errors and omissions insurance, which is a specialized liability insurance. Software companies think about special coverage for cyber risks, and I mentioned deployment practices. Next question, when coming to US, I frequently get the question, can I work here? And the answer is no, unless you have a proper visa or permanent residency, which comes after. And that can be a challenge. Immigration policies, by the way, change constantly. I've had a client who's waiting for a visa interview for about a year at this point, even though all the indications are there that person should get a visa. You have to think about IP protection and strategy. Whether to seek patent protection. If you're a software company, many companies don't do it. How to protect your trademarks. and seek advice on not only US but worldwide IP protection. And companies who deal with personal data, they have to navigate a whole new world of data protection laws. I mean, in Europe, obviously, you already have the GDPR and local rules. When you enter US, you are not going to lose those, but you get on top of it CCPA, the California Consumer Privacy Act, which can be just as painful or more. And you have to start dealing with immediately about special issues in connection with data transfer across borders. Some other maybe newer, more specialized topics that you face in the US are international trade. Not irrelevant for Baltic countries. If you keep your operations in Baltics and operate in the regions and were to do business, for example, with Russia, which I've had come up, is you immediately have to see whether your Russian business partners could be on the US official sanctions list, which means that you cannot actually do business with them. You have to deal with ADA compliance if you have a consumer-oriented online business. One of my clients got sued because their website wasn't accessible to the blind people. If you come to the US, you have to deal with national security or what's called CFIUS matters. Especially if you take foreign investments and are dealing with sensitive technologies, you have to at least analyze whether you need to get special approval from the US government in order to take that foreign money, because US government does not want foreigners to control certain sensitive technologies. And a new emerging topic, ESG, or environmental, social, and governance issues. Investors are more and more asking US companies, including startups, to think about how they view environment, sustainability, diversity, inclusion, and related matters. Finally, of the legal topics, once you do come to the US, you still have to deal with the relationship between the US parent and your foreign subsidiary. How will the operations of the Baltic subsidiary, if you keep one, be financed, considering the funds will be raised in the US? There are frequently intercompany services agreements used, but this is an area that you have to rely heavily on your tax accountants and tax structuring advice to get it right, for which you probably don't have money very early on, but at one point needs to be addressed. All right. To conclude, question: when would you go to the US? And there aren't like a right answers, but there are some points of time when probably it makes most sense. The first one is you could decide, I want to be in US. I'll go there from the very beginning, if you know that you want to stay in the US. You can then also wait until there's an investor that requires you to come to the US. It can be an accelerator or it can be an investor. Or you can wait until you have resources to deal with all those US issues, which are all manageable. You can deal with them. But something to keep in mind, the more you wait, the transaction to come to the US can become more complicated and more costly, especially if you've been in existence already for a while. All right, that is all I wanted to talk about, and I'm looking forward to the discussion.
Thank you, Taavi, for this really, really great and useful overview. Before we proceed with the panel, Ulla and Vitenis will make a general introduction as well and provide their initial thoughts regarding conducting business in the US. So Ulla, please.
Yes, hello everyone. My name is Ulla Helm. I'm the VP of Legal and Compliance in Veriff. And those of you who are not familiar what Veriff does, then Veriff is a global online identity verification company that enables organizations to build trust with their customers through intelligent, accurate, and automated online identity verification. Veriff was founded in 2015 in Estonia, but we did the swap to US in 2018. So we have the mother company Veriff in Estonia. And Veriff's total secured funding to date is approximately 93 million USD, including the latest Series B funding round of 69 million, which we did in April, thanks to Sorainen team, who was a big help. So I joined Veriff almost 2.5 years ago and started as a one-woman show, and the team has grown to 10 lawyers to date. And yes, it's been, I would say, Davi, where were you 2.5 years ago? It has, reading your slides is exactly the advice we needed 3 years ago when we did the swap. So hope to keep contact with you further on. Definitely good advice from your side. Thanks.
Thank you, Ulla. Vytenis, could you please proceed?
Hello, guys. Thank you, Mirel. Thanks for the invitation. It's a great pleasure to give a presentation during this conference. So, yeah, my name is Vytenis. I'm a co-founder of nanoAvionics. It's a Lithuanian company which manufactures small satellites. So you can think about that, satellite as a vehicle, as an automobile, right? We build that chassis, we put their engine, we put their other parts, and our customer is coming and they are giving their instrument, for example, camera or telecommunication equipment, etc. We combine them together and we help them to launch into orbit, and then they do business. I mean, do Earth imaging, do some communication stuff, etc. So the company was started in 2014. Now we have, let's say, 3 legal locations here in Lithuania where we have been incorporated originally. Then we have a daughter company in UK. We have managed to establish it before Brexit, so it made some things a bit easier. And finally, we have an entity in US, which is our sister company. So it's not like not like a daughter company, but sister company means that it has been like reestablished as a parallel company with the same shareholder structure, but it doesn't have any ties with Lithuanian entity. So again, for some legal aspects, maybe we will discuss them together. And yeah, of course, it happened after we found an investor from United States, and we are kind of Lithuanian or European Union originated company, but we are 51% owned by US holding. We have done this to enter US market more successfully. After all, the industry sector we are working in, it is called defense and space. So we have a lot of things related to US legal, let's say, environment, as Tavi mentioned, quite some of them. But in US, we have roughly 50% of the entire market. I mean, globally, right? So there is US, which makes 50% of the business, and there is the rest of the world, which makes another 50%. So for us, entering US market was crucial, and we were seeking for the best way to enter that market, having in mind that, let's say, myself and my colleague, which are 2 co-founders, are Lithuanian nationals, and in order we want to access governmental programs in US, we have to be as much American as possible, because there is ITAR thing, International Traffic in Arms Regulation, Import-Export, Buy American program, etc. So shareholder structure is very important, and data exchange, for example, between the entities. So for example, we sell some hardware or software in US, and as Lithuanian nationals, in some cases, we cannot even know what we're selling or what we're dealing with, because only US nationals can do that. So in general, this is interesting, but through those last years, after we incorporated nanoAvionics US, we had to learn a lot, and it's a big country, the legal environment is complicated, and it was interesting, and it's still interesting. So yeah, I think we will discuss maybe in more details later, but yeah, this is my introduction, and thank you again.
Thank you, Ulla and Vytenis. We are now proceeding with the panel part of this block. And to start this off, I would like to ask something that Taavi actually a bit already covered in his presentation, but I would like to go a bit more specific here. So why and when should a Baltic startup even start to consider flipping the company to the US, meaning taking the top go to the US, but keeping the important part of the business here? It is common that it is done because an US investor kind of demands it, but we have several Baltic companies who have investors from the US but have not made the flip. So Ulla, maybe you could give your thoughts on this.
Yes, thanks. Yeah, I guess the why is evident. For some, it's chasing the bigger market. For some, it might be even a requirement. For example, by participating in a US accelerator, they definitely require you to establish a local presence. But in terms of Veriff, so now looking back, the founders have said that Veriff should have gone global right away and not stay pursuing the Baltic market for so long. However, at the same time, Estonian market is a great testing ground for new products because and for solutions, as people are very tech savvy and eager to try out new solutions. But in terms of when going, I'm quoting Stefan Diedrich, who has said golden words that for your company, there can be no US success without US funding, yet there can be no US funding without US success. So, and this is very true because US VCs are ready to invest when they have seen your product fit to the market first. First iterations and success stories, they want to interview your clients. But at the same time, it's getting to US market. It's very difficult. You need to have very good go-to-market strategy. You have to have the right employees to establish the presence, who know the market and know the right contacts. You have to have lots of funds. So yeah, it's definitely. I also asked Karel Kotkas, our founder, a quote, and he said it's a matter of timing, but it's also you need to do it right away because it's so time costly. They had no idea that it takes so much time to actually establish a presence. So it's a difficult market definitely to enter into.
Mm-hmm. Yeah. So Ulla, and if you look back, then you would say that it was a good decision to go. You would do it again, but you would do it sooner.
Yes, definitely. And of course, there's lots of hardships, lots of gray hair. Taavi already outlined them in slides. There's lots to do for the legal counsels, definitely.
Mm-hmm. Vytenis, and the same question to you.
Yeah, the answer to this question cannot be, so straight. In our case, this is, I mean, the only one way to go. I mean, we are working in the niche sector. I mean, space business is still, well, so to say, from one perspective, looks very romantic. From other perspective, it's like business. I mean, it's not, of course, like commodity business. It's something like automotive, but or at least we would like it to be like automotive, but it's, of course, the scale is much smaller. And in our case, I mean, where we see 50% of the global market, there is no other way, to be considered. We must enter there. And of course, when historically we started from Lithuania, I mean, it was like 10 years ago. When we first started to raise funds for that, I mean, I remember, I was going to Practica Capital venture capital organization, which is working, in Estonia and in Latvia and in Finland also. So of course the guys were like, looking to us and then scratching their heads. I mean, space business in Lithuania, but we somehow convinced them. We've got that seed investment and it was successful. So, when we started like this, of course, the consequences, I mean, the kind of, it was good that we took some time to mature the product. And it was, let's say, better to do it to wait until that moment for a little bit than doing it too early. Of course, if it would have happened vice versa, if we would have established the entity right away in US, for example, in Silicon Valley, maybe the story would have been, different, because 10 years ago it was kind of hype of small satellites. In this part of the world, it wasn't usual. In US, it was like spec process today, right? But I think the timing was right for us, but every company should pursue for that. Unless, you look to other direction, to Asia, for example, maybe India, maybe China. It depends. In our case, it's like global business. Satellite, flies around the globe in 90 minutes, in 1.5 hours. So it gives you even better perception of how global this business is.
Mm-hmm. Yeah, thank you. Yeah, I think that it makes totally sense that if you have a business need, then of course. Taavi, listening to their stories, how would you comment it?
No, I agree. If you are convinced that you want to come to the US, and that's the discussion I've had with others as well, that you want to seek US investor money, or you want to sell your things in the US in the end, I think you have to come as soon as you can. There are some costs, there's some headaches up front, but to deal with them later is going to be just even worse. Once you've already kind of established your operations elsewhere. So don't even kind of set up your Estonian, Latvian, Lithuanian entities. Set it up in Delaware. It's easy, and then create the Estonian subsidiary to it. You don't have to deal with any flip transaction whatsoever. You start out there, but you have to be convinced that this is the right thing, because is this really the US that draws you, or is it something else? Maybe you can do it in London. London has been a very successful destination for many companies, and it's not impossible to keep in your country as well. Sorainen knows well. We've talked about that with some incredibly successful Estonian companies who have stayed in Estonia, and it's not impossible. There are investors who will support companies early on. But yeah, if the US is if you know that you will be eventually in the US, I agree. Go to the US early. Learning pains are also easier when you still are not moving 100 miles per hour every day.
Yeah, thank you. Knowing that we learn best from the mistakes we have made. So could you please list the biggest and maybe also the weirdest and surprising issues your company has faced due to the US element, and how did you actually manage to solve these? Vytenis, please.
Yeah, actually, we had some things like this, and strange things might happen in US. For example, there was one story, right? There was a request from one of the customer who is partially funded by government, right? Who is seeking to launch services based on the satellites. So they sent a request to the US colleagues, US nationals, and those guys sent a request. It was engineering related stuff. So, sales guys resent that request here to Lithuania. And it was so, innocent thing, just a regular thing, to discuss with, regular guys from the systems engineering department. But it appeared that information was somehow sensitive. So we had, to go through various declarations, that we almost breached ITAR stuff, etc., which from our perspective looks just, innocent and a bit, overcomplicated, right? So no one knew about that. It's not a big deal. We didn't get any penalties, anything, but in general, we had to declare that, okay, sorry, some sensitive information might have been leaked, but, so that was a bit strange stuff. So, then we have things like this, we have to involve lawyers. We have to deal with the guys. After all, this is like 3 lines email, but we have spent like 2-3 weeks to solve this thing. And it's strange. I mean, so we have to be very, very careful. And the thing is that we now have to kind of mimic the same structure, or of course smaller as for now, like it is in Lithuania. So those guys can support questions of this kind immediately, addressing them without involving us, like, you know, nationals of European Union. It's strange, but it is how it works actually. So this is one of the stories, I mean, we had, but this happened quite recently, and we finally solved it after 3 weeks actually.
Okay, thanks. That's really good to hear. And Ulla?
Well, I asked from our founder and co-founder again, because I wasn't on board while they were doing the flip and Series A, and taking some lessons from them. But they actually say that you have to wait for the unexpected all the time. You know, expect the unexpected. And there is no mistakes. It's just we see it as opportunities to grow. And I can speak only from my professional experience. These are not mistakes. They are just lessons. Is that legal advice in US is really expensive. It's yeah, Tavi is nodding. It is really expensive, and US law firms take you on board with the vision to advise you through the fundraising rounds. They don't want to give like one-off advices. So we have a law firm that advises us through our fundraisings, and we wanted to take advice from another law firm which is East Coast and closer to our time zone. And when they found out that we had done Series B, they basically cut the partnership because they were a little bit disappointed that we did it with someone else. So that was interesting, as well as the corporate governance. Let's say shareholders agreement in Estonia, it consists of one document. In US, there's a big batch of documentation. About 3 of them, Davi, right? So it's kind of it's a much more documentation. Then what could I point out more? Yeah, I guess these are kind of the professional takeaways from this kind of the 2 years that I've been on board.
Yeah, I can agree. Legal advice from good lawyers is expensive in the US. There's no question about it. I mean, I've seen what it costs to do business in the Baltics versus the US, and I mean there are different providers, and I mean different law firms have their different pricing arrangements. So definitely ask around, and it's not only lawyers; it's also all kinds of other service providers that can eat up quite a bit of cost, and accountants as well. I'm actually, yeah. I agree with Ulla. The package of documents, it's not 3, it's 5. I mean, this is the 5 main documents, and they are like 100 pages at least, more probably. But I think the interesting part of it is, if you are in the area and you have the lawyers who deal with those documents, it's actually easier in my mind. I've recently had a financing where the founder, who is not US, told me this is by far the easiest fundraising and smoother fundraising that I've ever seen, because everything, I mean, and the reason why it was so was we used this 5 documents, but we didn't mess with them too much. We just did what kind of the basics, and we didn't start inventing all kinds of weird, crazy things. And as long as you stay within the boundaries, it's actually not that hard. The challenge is, and where the legal fees start eating up, start accruing really fast, is when you start to come up with something unusual. Then it's not only that you have to hire expensive lawyers, expensive lawyers also have to spend time with you. And it's not only like an associate who can change names in a document. Somebody has to actually think through and put those together and advise you and negotiate. And costs there can add up really, really quickly.
Yeah, I totally agree. If I worked with Ulla on the US fundraising, then it was for me one of the biggest US fundraisings I was involved, and it was quite surprising for me to see how template-based everything was, and all the US lawyers expect everything to be quite on the same frames. I don't even know whether it's always a good thing or a bad thing, but it was either way it was surprising. But Taavi, what do you see as the first and biggest mistake startups have made before they come to you?
It is not usually a legal thing. I mean, legal thing is mostly about expectations of startups think that things are really easy and cheap, but that's more of an expectation on the business side. I think before coming to your US lawyer, I think you have to do some homework. The biggest mistake is coming to your lawyer without doing homework, both on the business side, knowing exactly why you want to be in the US and how you're going to get the money and why do you need to be in the US, frankly. And then also talk to your peers who have done this. You can avoid legal costs. I always try to tell my clients that my goal is not to make money out of the startup. My goal is, like Ulla said, get through your funding rounds. And frankly, not even funding rounds. Funding rounds are not the big profit center either. Profit centers are when you have made it, right? When you go public, do a SPAC deal, or sold for $5 billion. That's where we want to really make money. Let's put it this way. Now, to say Ulla, I mean, I do advise companies day-to-day basis as well, even if they do financing elsewhere. But that is a law firm mentality. We don't want to make a whole lot of money, so we don't want to actually spend too much time. And you can avoid a lot of legal costs by just doing some homework. You should still talk to your lawyers because things change and others may have bad experiences. But the biggest mistake is ask around and be a little bit prepared and challenge your lawyers too. Lawyers will be, initially they say, hey, here is how it's done. And can we do it more easily is the question. And sometimes it is. It's not that unusual. We don't have to do everything by the book. Most of the time, by the way, in my mind, makes sense to go by the book. Do it what's standard. It just avoids the cost. I mean, the founders or startups' biggest risk is not in the legal documents. It's whether you can actually be successful and sell your product. And focus there is always my advice.
Yeah, totally agree. Thank you. As Taavi and Ulla already said their thoughts on this, then Vytenis, in your opinion, main things to consider when using a US law firm or advisors, your experience? Yeah,
actually, we already have quite an interesting experience with that. And what I should say, I'm much more happy with actually the services we can get here in Baltics. I mean, I'm not particularly praising anyone, but I mean, we're working with Sarainen and we are very happy because you can get, at least as I feel, I mean, the advice is much broader. At the same time, some other aspects are being considered. If you are solving one problem, in the US, it's kind of a bit narrower approach, right? And maybe more deeper approach. And you just cannot ask general questions like about taxes, right? You have to find like, income tax specialist or corporate tax specialist, etc. If you're working, I mean, here, so you can get much broader advice, kind of, multidisciplinary, so to say. And what we do our homework, as Taavi mentioned, in advance. I mean, we have to, in US, we have to narrow down our question as much as possible. Otherwise, it will be very expensive. It will be very long. I mean, you ask the guy, he will involve another 5 guys. And then, they will charge, each of them will charge like, 5 hours, and the rates are, I don't know, double or triple comparing with our rates here. I mean, so yeah, the homework is very important, and it's very important to understand what are you asking. So it's it's important. Otherwise, it would be crazy expensive. I mean, we have this experience, before, and in general, the legal environment is different. I mean, there is no such a code, right, where you can, find, some things described already there. The American style contracts are much thicker, right? And there are a lot more things than we have here. But yeah, it is as it is. So yeah, I agree. The homework is very important here.
Taavi, would you like to add something? Sorry?
No,
Yeah.
And I'll be honest, US law is so specialized at times. I will not give you a whole lot of tax advice. I mean, taking that back, we're just going to talk about taxation of stock options in a few minutes here. But one question that we got from the audience is, what are tax concerns when flipping your business from Baltics to the US? Are the taxes on transfer of business assets, IP, etc.? Ideally, I would tell you what it is. But we are entering into an area that is incredibly complex and incredibly fast-paced changing. 2017-18 tax reforms changed this area as well, how the US corporations are taxed on their worldwide income. I would be probably not going to jail, but committing malpractice if I started advising on deep details of this. All I can say in that area is you've got to talk to your tax accountants because they will in the end be the ones who will take a position on the tax return, and they have to sign off on this. We can also help you, but you're probably better served by talking to a tax accountant than a big law firm tax lawyer, who are, by the way, more expensive than corporate lawyers generally because of their highly specialized knowledge. So there are tax concerns. Tax concerns are both when you pay for the IP in the foreign country. The U.S. Estonian tax treaty, I know at least, has a withholding on payments for IP, and how to navigate that minefield is just problematic. I don't think that there is one right answer either. It depends on what the IP assets are and where they have been created, and when you transfer the IP over. So, but yes, on that question, I very much expect I would send you to somebody else and not deal with it myself, because I will send you a specialist. And doing your homework and knowing a bit in advance will avoid you to getting the 5 people on the phone, but getting the right person more quickly. Me as a corporate lawyer, and you when you deal with the corporate lawyers, the corporate lawyers should kind of guide you to the right place sooner, but we never know. We always don't know either what is the specific concern, and we don't even know what the right questions to ask are often. But sometimes we do. So that's what we are trying to do.
Thanks, Taavi. And actually, you a bit already started to touch the next subject I would like to raise here. Actually, a lot of our listeners sent this question beforehand, and they're really interested to know, how should you run your company in practice when you have either a topco or a subsidiary or a sister company in the US? I know that we can't be really specific here, and it's really a case-by-case thing. But trying to be even more specific, how the companies manage the use of the IP, how to kind of ensure that there are no issues in relation to taxes, or at least that they're mitigated when one company uses the other one's IP and employees. And Taavi, maybe you can start with this.
Yeah. So there are 2 sides of this story. One is investor expectations. What will investors be worried about when you set this relationship up? And the other side is how to optimize your tax picture generally. When you are in the very early stages, I have not seen this come up as a big issue either way. The investors usually are okay, so long as it's clear that either the topco or the subsidiary, one of them owns all the IP. So the key is all the employees and your contractors who have developed your IP have to give it over to somebody in your group, whether it is in the Baltics or whether it is in the US, so long as the local jurisdiction is reputable like Baltics. If you do it in Nigeria, we maybe get concerned, but as long as it's in one of those reputable jurisdictions and it's clear that IP belongs to a group company, investors usually don't care too much. Tax planning, on the tax side, it usually doesn't matter early on because, I mean, it's not worth that much. The dollars involved are not that great. So in my experience, what happens is early on, I have seen companies set up a basic services agreement between the topco and the subsidiary to be able to put the funds that you raise in the US topco to the subsidiary. You do some basic kind of avoid paying outrageous prices to not get into trouble with transfer pricing rules. But some sort of a cost plus approach with some markup to the costs usually works early on. As the company develops and gets bigger and the tax issues start becoming more important, then we would send you to a tax accounting firm who will actually do a somewhat more involved tax structuring analysis. It does not necessarily need to be one of the big the big four accounting firms. There are plenty of others who have this experience, but somebody who is experienced in structuring this relationship from tax perspective with their right forms to make sure that you don't get into trouble with transfer pricing rules. You just have to take that step at one point. So that is my experience. Early on, it does not usually matter that much.
Thank you. And unfortunately, I see that actually our time is up. All our performers will be here during the whole webinar. So if you ask questions in the chat, these questions will reach the performers. So please do it. And overall, thank you, everyone. And hopefully this panel has helped all the listeners to understand better what to consider when entering the US market on raising funds there. Naturally, we were not able to list everything here, but hopefully the panel has at least provided you food for thought when starting to consider whether to take some action. I thank you all from my side, and I am glad to give the floor to Kaido Künnapas, our tax specialist, who is leading our next part of the webinar. Kaido.